Welcome back to Canadian Justice, where we're discussing a recent case heard by the Supreme Court and the question of whether or not you can sue the government for damages suffered under an unconstitutional law. Now, the current standard, and what we at the CCF argued as interveners in this case is the correct standard, is that you can only sue the government when the law was enacted in bad faith, was clearly wrong, or was an abuse of power. Now, Josh, can you explain what those terms mean and what might be some examples of laws like that?
Yeah, so bad faith, and Gerard makes the point that this would be quite difficult to prove, but it would be where the legislature does something that's deceitful. So, for an example, perhaps the legislature wants to pass a law that is unconstitutional because it targets, for example, Indigenous voters, and they say that this is what they want to do, and they get legal opinions, and they realize this is unconstitutional, so they write a law that achieves the same purpose, an unconstitutional purpose, but the text of the law appears to be constitutional. Well, that might be a case where we could say there's some bad faith going on. An abuse of power might be something like the government decides to ban a political party, which is clearly contrary to Section 3 of the Charter of Rights and Freedoms, which says every citizen can be qualified for to stand in the legislature. And in that case, maybe they're not deceitful. Maybe the minister stands up and on second reading says, I know this is not charter compliant, but I'm going to do it anyway because it's particularly popular. And that's a very unlikely scenario. But if that happens, there needs to be damages available in our view. And
Now,
then if
Josh,
they're
it
wrong,
sounds unlikely, but Germany has banned certain political parties, and maybe they may be unsavory parties, but the banning of political parties is not something that is completely unfathomable.
yeah, a lot of these things they seem unlikely and they seem far fetched, but that's only until they happen, right? So you could look at something like the trucker protests in Ottawa. I don't think most of us thought that the government would be freezing bank accounts of political protesters, but that happened. And lots of these things have happened in the past. There are other abuses of power like Japanese internment in the Second World War. Torture throughout history has happened, and we know that's unconstitutional now. Every legislator should know that. So if they do that, our argument is that they should be held accountable, not just through a declaration, but also through money damages, because that's the type of thing that actually, punishes the government, deters them from doing it again, and in some cases actually compensates the people who have been harmed. And the other
Gerard, is there?
situation here,
I want to give Gerard a chance to get in here.
Yeah.
Is there anything you want to say in response to that, Gerard, or about this question of what do these terms mean? Bad faith, abuse of power, or clearly wrong?
I have nothing to add about the terms. I just would like to point that most of these hypotheticals are pretty fanciful. I haven't heard a clear case, maybe Japanese internment aside, but I'll come back to that in a minute, where there's been obvious bad faith that we would say that damages are clearly warranted. Attorneys general almost always come up with a plausible reason that something is charter compliant, or at least can be justified as a limit on charter rights under Section 1. I have yet to see an attorney general stand up and say, this is not charter compliant, we're going to pass it anyways.
Right, but Gerard,
Uh,
isn't that sort of the point? I mean, we were at the hearing, and one of the things that the Supreme Court uh, considered was the Crown said we don't need to worry about these hypotheticals because this would be a rogue parliament doing that kind of thing. But isn't that the point, that you want some type of restraint on a rogue parliament, and damages
yeah.
is one?
And that gets to my, I guess, my other practical problem. I have limited faith in the courts to keep this an exceptional remedy. We've seen lots of instances in charter case law where what was supposed to be exceptional in terms of either justifications or unlikely ways that something is going to be limited, or doors open for prospective future rights violations that become more and more open over time. So I am fearing that we'd actually be opening Pandora's box for some pretty theoretical benefits.
Now, this also was raised at the Supreme Court hearing, and what some of the justices pointed out was that the standard that we have is the standard from Mackin, which is, I think, a 20-year-old case. So if we're concerned about Pandora's box, I mean, Mackin gave us that box 20 years ago, and we haven't seen these types of, you know, multiplication of these claims and successful claims against the government in the 20 years since we've had this standard. Now, we don't have time to answer this right now. We've got to go to break, but I'll expect your answer when we're back.